in a moment, we will be live. So we have with us this evening Ayushi Richa Mishra. She is an advocate practicing in the District Court of Pune. She in the areas of information technology, cybercrime, and other IT laws. She is a visiting faculty at National Insurance Academy and Police Academy, where she teaches about the information technology laws. In this particular session, which is hosted by LawSikho under the project Maverick, wherein we are aiming at providing free CLAT assistance program. Under this program, today we have Ayushi with us, who will take us through with the basics of criminal law. And I will be there in this session to connect those topics to the law entrance examination. I must tell you in the foreset that the basics of criminal law have been asked in law entrance examination numerous times, whether it is CLAT 2015, CLAT 2016, or whether it is before the CLAT started, the exams such as NLS 2003, 2004. They have tested this. BHU in the year 2010 has tested this. AILET in 2006 has asked question around this particular area, which is related to basics of criminal law. So here, I would ask Ayushi to take us through the basics of criminal law. And in this today's session, we'll be covering up areas such as element of criminal law, stages of criminal law, and other areas which Ayushi would like to cover. And I would be linking it to the law entrance examination. Ayushi, over to you.
Okay, so first of all, I hope all the viewers are doing fine amidst this corona scars. And I would also like to thank Harsh and LawSikho for inviting me to speak on the topic of basics of criminal law. So first of all, as we all know, we as lawyers have a habit of breaking the things down, whether it comes to reading the case laws, reading the sections for our brevity, for our benefits. Obviously, we do not per se break the law, right? So first of all, basics of criminal law. What is law? What is your understanding of law? And you as aspirants for law prep examinations, you must already be aware of what law is, as you must be preparing for it. But let me tell you what, in my wordings, what I believe law is. Okay, law is something which is a set of guidelines, a set of rules, a set of regulations which are meant to keep people within the frame, right? It is for protecting and also for prosecuting who, by way of conduct or in any other manner, try to break the law or try to, violate someone else's right. Okay, so you must have also read, or maybe at least have heard, that wherever there is wrong, there is a remedy. So law is a remedy, and law, sometimes some laws are there which actually punish you, right? Some laws are there, some laws actually protect you, right? Motor Vehicle Act is one such, that you may be, may not be carrying your license, you may be doing drunken driving or anything like that, right? So Motor Vehicle Act is there for you. Then when we talk about constitution is there to protect your rights. Okay, so here uh, I think we are clear with the definition of law. Now let's talk about what is criminal law and why do we actually need to study criminal law, and how important it is to understand the veracities of criminal law. Okay, so criminal law, why criminal law? Why do you call it criminal law? So we live in a society, we have like started from the revolution of a wheel to now, where we are sending our own Mars mission, right? So crime is something which we live within, we live with, all right? And we, every day we breathe with crime. Everywhere, anywhere you see, there is crime. Okay, and crime is something, what is crime? Crime is nothing but act or omission, right? You may do something and you may have omitted to do something. This more or less constitutes a crime or an offense, right? But how does crime behave? what is the difference between civil law and criminal law? How these two words are different from one another, civil and criminal. So let me like quickly take you through it. So civil law is something where parties are in question, one on one. Okay, it is like right in rem. Okay, in civil law there is this one plaintiff who is filing a case against another. The aggravated party is filing a case against another for restitution of his rights. Okay, and when we talk about criminal law, when we are talking about criminal law, there is this one person who is the perpetrator of the crime or an offense. He is committing a crime, definitely maybe against one person, two person, or 10 persons, but it is considered as a crime against the society. Because if, for an example, you are living in a vicinity wherein okay, every day robberies are happening, and some or the other guy is teasing some other girl. Okay, now if one girl or if one person is robbed, or maybe his pocket is picked, then everyone in that area is terrorized as to, okay, this may happen to me someday, this may happen to us some other day, someone may actually break into our house someday. Hence, criminal law is differentiated, wherein it is a crime against the public at large, or a crime against the society. So when we talk about criminal law, the state, right? The state is there to prosecute, or the state is there to file a case against that other person. Okay. Now, when we talk about criminal law, there are a lot of important things you need to understand, that how does crime begin. Okay, how? So let us understand that earlier the crime used to be like someone has taken up your uh, maybe you're in the library, someone has taken up your laptop without your consent. Okay, so these words play a very important role. If someone has taken away your property, okay, from your possession, obviously without your consent, it becomes theft. This is one crime. Okay, maybe you are sitting at your friend's place, you like someone's pen. Okay, this is nice Parker pen. I think maybe I should take it away, the friend won't say anything, you just take it away. It is theft anyway, right? And now we are living in the times of computers and technologies. The crimes have also changed. Now the crimes we know of are phishing, wishing, right? Cyber squatting. I may be committing source code theft. I may be committing frauds of various kinds, right? So crime has evolved, and law again is there to protect you against those crimes, right? This is why the law is for. And basics of criminal law, right? So first of all, we need to understand there are three fundamental principles when we are trying to understand the concept of criminal law. The first one is that, as I already stated, omission, act, or omission must be there. Now, what is act or omission? I have done something, right, which may contribute, or which may, the consequences are such that which may hurt that person. Okay, it may be a bodily injury, it may be a mind injury, or anything like that. Okay, so first is there must be an act or omission. Second is that there must be a criminal intent. Okay, I must have an intention to cause that harm to that person. And the third one is that such an act or omission must be prohibited by the existing law. So these are the most important three fundamentals of criminal law: act or omission. Second is that criminal intent. Now, when we talk about intent, there are many other things that come into play. What is intent or intention, what is motive, and what is knowledge, right? There are three different things we actually need to focus about. We as law students must be quite clear about these three concepts. What is intention? Intention is why I want to do something. Okay, then you will say intention and motive sound more or less same to you, right? For example, I'll give you just a very small example. So you are going to a shopping mall. Why you are going to a shopping mall? Because you want to do shopping. Yes, I want to do shopping. I am going to the shopping mall is my intention. My intention is shopping. And now why I want to go for shopping is because maybe my clothes have gone old. So now my clothes have gone old. Now this is the motive of going to shopping, right? There is one more simple example, is that A slaps B. Now why does A slap B? A slaps B, this has happened. Now my intention is to slap B. Why did I slap B? Because earlier I remember that B has slapped me at, I was in the college canteen, B came to slap me. Now this becomes my motive. This was my motive to slap B. So basically they derive out of one and the same thing, but they are definitely two different things. Okay. Motive act as an ulterior object. Okay. Motive is my ulterior object to commit a crime or commit an offense. Right now we talk about knowledge. Now what is knowledge? Well, how these three things are different. Now I am going to a place, and I know my friends are there, and one of my enemy is also there. I don't like that person, right? I know that okay, that person is voluntarily getting intoxicated, and I also know that when that person gets intoxicated, that person actually doesn't have an idea as to what is happening around. Now I would say that okay, this is coming to my leverage, and I would take a benefit of this thing. So now I go there and give him a hard blow on his head with a baseball bat, or maybe a glass, for instance, to make it very practical. I have a glass, and I just, or a bottle, I just smash it on his head. He doesn't have any idea as to what is happening, and I know that the blow that I've given on his head, or the smash I've given on his head, is likely to hurt that person, or nothing but he may definitely get hurt or may grievously hurt if the degree of that harm that I've caused is that big enough to cause hurt to that person or any bodily injury to that person. Now when we talk about, yes, I know that if I'm beating that person with a baseball bat, with a if there is a knife, if I'm stabbing that person, or if even if I'm having a gun, in all these three situations I have a knowledge what kind of different harms these three things can cause that person altogether. Now this is what knowledge means. Okay, I am me having a knowledge about something. This is what knowledge is. So intention, motive, and knowledge. So the next thing now that I would like to cover is that uh, two essentials of crime. What are the essentials of crime? You must have, I believe you must have studied, and even if you haven't, so
Ayushi,
yes.
before we come down to the essentials, kids, there was in CLAT 2013, as Ayushi ma'am has already told you about the act and omission. There was some question with respect to that, that whoever causing a certain effect or an attempt to cause that effect by an act or omission is an offense. Is to be understood that causing of that effect partly by an act or partly by an omission is the same offense. Around this, the question was revolving around that a particular person intentionally omitted to give food to his father. He also used to beat his father. Consequently, A's father died. So, yes, this particular thing which she told you about the act and omission has been asked a couple of times in law entrance examination. So now we can take it ahead, Ayushi.
Okay. So thank you for the explanation. That is definitely going to be very helpful. And now, two essentials of crime. Now, the two main essentials of crime are mens rea and actus reus. Now, what is mens rea and what is actus reus? Okay, so mens rea actually means having a guilty mind. Okay, now, but how can you actually devolve this idea that there was a guilty mind or there was not a guilty mind involved, right? So there are a few things that you need to understand when we talk about mens rea. So first one is that there has to be an intention. We know what intention is involved. Then comes knowledge. We have again seen what knowledge means, but again let me run you through it. Intention is something, the purpose why I am doing something, right, is my intention. You are preparing for CLAT, LSAT, or SET, or whatever examinations that may be. So your intention is to pass that examination, right? And what is your motive? Your motive is to study in whatever law school you want to be at, right? So here, intention and motive. Now the second part is knowledge. You have a knowledge that these all set of questions actually according to the trends, if you see the trends, you're looking at trends, you're looking at the past year paper, so you have a knowledge that if I study these things, if I cover these things, if I do complete hard work, I may actually crack this exam, this thing. Then comes rash and negligent act, then comes dishonestly, okay, doing something dishonestly. Now how dishonestly and guilty mind are actually linked. What is guilty mind? Okay, sometimes, if your mother gets you some chocolates and she says that, okay, don't eat it now, you eat it after 2 days and keep it for some time or whatever. You otherwise also, you go because you like chocolate so much, you go and you have it, you eat it, and then after 2 days you feel like, okay, I should have eaten it after 2 days itself, because now I want it. Now you're feeling okay, guilty, kind of. Okay, it is definitely not so much related, but I'm just trying to give you an idea of how guilty mind works, right? So dishonestly, what dishonestly means? What is dishonesty? So dishonesty is actually defined in section 24 of IPC as to causing someone wrongful gain or wrongful loss. How do you cause someone wrongful gain and wrongful loss? Okay, so since I am quite active in the area of cyber crimes and cyber laws, obviously as an advocate, so wrongful gain is that if I am trying to, I call someone that, hello, I'm talking from SBI, and your debit card is expired, and if you give me this OTP or this number which is generated, I'll restart your debit card, or it will start to function properly and smoothly again. So what I do is that I'll in good faith, all in good faith, I'll just give away the OTP since I have no knowledge as to the consequences.
Ayushi,
I'll
are you referring to the web series Jamtara? It was actually involved around this.
I was not actually referring, right? But yes, you can definitely consider it as a big example as to what wrongful gain and wrongful loss is that, right? So it has caused me wrongful gain and that person in an illegal manner. So the word illegal is actually mentioned in the section 24 of IPC. So the word illegally, it revolves around the word illegally. Now someone has actually illegally tried to siphon money from my account, take away my money. So this is how, again, wrongful gain and wrongful loss works. It is very important to understand these words: dishonestly, fraudulently, wrongful gain, wrongful loss, because trust me, it will help you in the long run. When, if you are interested in the field of criminal law, if you are willing to make a career specifically in criminal law, if you want to do litigation in criminal law, these words are, they will act as a charm for you, right? So the next word is fraudulently. Now what is fraudulently and what is fraud? So again, as students of law, we need to understand the word fraudulently very carefully, because I believe you must have studied contracts. So in contracts also, there is this word fraud comes into picture. Again, when we are talking about criminal law, it is definitely already there. So what is fraudulently? What does fraudulently mean? Now when we talk about fraud, I already have an intention to deceive. Okay, so again, mind you friends, the words intention, motive, knowledge will completely come around. Okay, they will again come into circles time and again. So you need to be very clear about these three words. So now I have an intention to deceive or an intention to defraud, right? I'll just give you a very simple example, that if I want to buy my friend's car, right, and my friend already knows that there is some discrepancy in that car, the fuel tank is consistently, it needs repairs, or the engine is bad, and even after knowing this, that person is consistently, like, pressing me, okay, buy it, it is good, I'm giving it you at such good rates, buy it now. I have bought it, now I am facing problems and everything like that. Now who's responsible? The friend is responsible here, because that person had an intention to deceive me. Okay, that person has defrauded me. Again, I'll give you one more relevant example as to practicing is considered. So we had this case of this guy. They were into contracts. They were entered into an agreement as to providing a facility for the gym services, and the other person was actually hosting the services there. So that person, they entered into an agreement stating that for a term of 2 years, I'm giving you this facility on rent, and if something happens, so the person who's providing, obviously the who's providing the premises, would be at an edge to any time resign the contract. So this person, what this person does is that he is fine, like, okay. And when 1.5 year has passed, this person actually resigns the contract, and he actually brings the contract to an end, stating that, okay, now I'm not happy with you living here and you continuing your business here or whatsoever, so I don't want you to be here. Now there was no reason as to why this person has broken the contract or whatsoever. Now this case comes to us. Now what happened, actually happened, we went through the contract and the agreement, we went through the lease of that property. Turns out that person who was actually providing our clients the facility to continue their business activity of a gym, the lease was actually of only one year or 9 or 10 months, right? So when they entered into an agreement, my party, having a reason to believe that, okay, I am entering into an agreement for 2 years only, and I am getting this property for my work or whatsoever, for my use for 2 years. I did not have an idea that that person who is providing me his property itself doesn't own it for the proper term of 2 years. Now that person has defrauded me. Yes or no? So this is how this thing works. Now again, you need to be very much aware about the word reason to believe. What does reason to believe mean? Okay, so you must, if you have read some news online or you refer to some articles or judgments online, right, the word reason to believe comes into play a lot of times. Okay, I having a reason to believe had done something. Okay, I having a reason to believe that, okay, we are having a lot of viewers viewing this thing for the purposes of cracking their exam or studying for their exam or whatsoever, right? So reason to believe, again, I am having a reason to believe that there is a person standing next to me, and I need to go and talk to that person. But I don't know, I may be in some other zone, I go and hit that person. Okay, now these things will again be into consideration, right? So before I get to another topic, I would like to ask Harsh if he wants to connect it to the uh, flat prep parlor.
Yeah, so I hope we are getting into that particular topic, which is the stages of a crime. And the first and foremost, the term you have already used, which is intentional, which is generally not punishable. I will not go into the detail that where it is punishable, though there are certain exceptions to that. And I particularly believe that when we come down to that stages of crime, I will connect it to the law entrance examination. Will take you through CLAT 2015 and CLAT 2016 and endless papers.
All right, should I carry on?
Yes, yes, you can carry on.
So, mens rea. Now we'll talk about what actus rea is. Actus rea is something which I do by my act, or which I may omit to do. Okay, doing of something or not doing of something. You need to break these things, and whenever you're reading any sections, please always break the sections and then read it. So, to do something or to not do something becomes an act. Again, act itself, if I do something, does not become a crime until and unless mens rea or guilty mind is involved. Okay, so this is how the stages of crime begin. So the first one always is mens rea. All right, now the next point is preparation. What is preparation? Okay, so preparation is one of the most important steps of committing a crime. Before that, yeah, okay, I'll come to preparation itself directly. So I have an enemy, or maybe I want to take revenge on some person, and I hate that person. That person may be doing academically well, or maybe business wise or whatsoever. So I invite that person to my home, and I would say that, okay, come to my place, I have baked some cake for you for your success, and let's celebrate and everything like that. Okay, Now I've also asked that person, now consider these points as to what, how I'm planning this thing to be, right? So I would say that, listen, don't tell anyone that I am hosting a secret party for you. Let it be between ourselves, and if others come to know, then it would be again like, having a lot of people. So let's have a private party, and then we'll inform the other ones. So this is my first thing. Second thing is that that person comes to my place, and inviting that person beforehand, that come to my place, we'll have a cake or food or whatsoever, start begins with my preparation, that okay, I have began the preparation of actually uh, coming to a conclusion. Okay, so that person comes to my place, I have baked a cake. Now in that cake I have actually put some poison in it, right? Maybe I have put some cyanide in it, knowing that okay, now again knowledge comes into picture, that I have a knowledge that if I put some poison in his food, he is likely to die, he may die immediately. And even I may be aware of his condition, that okay, that if this person eats a lot of sugar, he may have cardiac arrest, he may have some stroke, or his BP may shoot, or whatsoever his medical condition be. Now I already have a knowledge that this may cause, this may threaten, this may be a threat to that person's life. Okay, that person comes to my place, that person says that no, I'm not in a mood to have cake right now, I'll be like pestering that person, no, please eat it, please eat it, please have it. That person eats the cake. Okay, now I have baked a cake preparation. Now I am forcing that person, please have a bite, have a little bit, have a little bit, at least have this much. Now this will be attempt to make that person eat. Eat it, eat it. Arey, please eat it. You're my friend, you're my buddy. I'm trying to persuade that person. And the last person would be accomplishment. If he eats it and if that person dies, and now I go and dispose of the body or whatever I do, right? So I won't train you as to how to dispose of things or whatsoever. Okay, it's all wrong, definitely. So this is how basically these things would work, right? So it would be preparation, attempt, and commission, right? These three fundamental things are there. Now there are also many different things as to preparation. Now I have my friend, we 4 or 5 friends are sitting, and we are discussing as to we have to take badla on some person, we have to take this revenge, and we lost a football match, basketball match to that person, and that person must be taught a lesson. That person maybe rebuked us in front of everyone, or even abused us or whatsoever, right? Now we 5 friends having discussion. Okay, now there are two different things coming into picture. What is one is common intention. Okay, section 34 of IPC. What is common intention? Now intention, I've already told you, having a purpose to do something. Okay, purpose, I want to beat that person. Okay, or I want to at least hurt or injure that person, so that would become my intention. And my motive is because that person maybe abused us all, this would again become my motive. So now we all four are discussing as to what to do, how to do, how we should take this into action, right? We will go in taxi or car, or on our bikes or scooter, whatsoever we go with. So this is we are how we are preparing. So there are two things come into picture. One is common intention. We all 4 friends have a common intention of going and beating that person, right? And we may be like assaulting the person or whatsoever we'll be doing. So these uh, things come into picture. Now how common intention plays. Now someone would say that no, that person was only driving, he was only driving the car and was dropping them to the venue of doing all this karyakram of beating that person. No, that person is also equally responsible, right? Because we all have a common intention to do this. The other person would say that no, how am I involved, I only got the bats, or I only got those baseball bats to the venue. The other would say no, I didn't do anything, the third person, the fourth person beat him up, I was only holding a blanket on his face so that he doesn't see us, right? They all are equally liable here, right? Now next part would be again, when if we talk about it, criminal conspiracy, right? What is criminal conspiracy? Now people are conspiring, right? They are making conspiracies as to what to do and what not to do. So again, this would become a very big topic if I take it. So 34 and criminal conspiracy 120 are very important, and I would definitely insist you all to read it once, right?
Ayushi, on this point of criminal conspiracy, there are questions which have been asked, and they have been asked about that the conspiracy needs two-person. हम लोग we already know that षड्यंत्र करने के लिए दो लोगों की जरूरत होती है. But in the law entrance examination, they have asked questions like, take an example. Harsh was looking at the mirror and he talked to his reflection that they should kill Karan Johar. Okay? So whether there was a criminal conspiracy or not. So we must consider that there must be existence of two-person. Like I cannot talk to the robot and say that let's kill someone, or I cannot talk to my parrot and say let's go and kill someone. So on the part of criminal conspiracy, this is the point where the question is asked. Also, Ayushi has taken us through the stages, and she is discussing right now the stages being IPAC. How do we learn that? Is I always take this in class. IPAC is इंसान पीने आए चाय, intention, preparation, attempt, and commission. If we go down to CLAT 2015, we have a question on preparation, like which Ayushi was telling us through that somebody keeps a poisoned halwa. Okay. Believe me, in law and examination, you will not get somebody keeping a poisoned pizza. So it will be around poisoned halwa or something kheer veer. So, and when somebody enters, so all about was that whether the preparation can be made punishable or not. So, with respect to this, there was a question in CLAT 2015 with respect to assertion and reason. When it comes down to attempt, there was a question again in CLAT 2015. There was a lot of question with respect to basics of criminal law, and then they asked us questions with respect to attempt. And I hope Ayushi will take us through the section 511 of the IPC, and then I will further connect you to the law entrance examination questions. Ayushi, over to you.
So when we talk about attempt, actually, attempt per se directly is nowhere punishable in the law, but there are actually a lot of sections which make it punishable, right? So if you may go through like attempting to waging a war against the state, right? This becomes punishable. If you talk about uh, committing suicide, attempt to commit suicide, it becomes punishable. Attempt to commit murder, this becomes punishable. So attempt per se, you'll have to actually understand as to why attempt is important, right? And the next one, just a second, the next one we'll be talking about is that I would actually like to ask Harsh to please meddle in.
Yes, Ayushi.
uh,
Where
511, what actually do you want me to cover?
uh, can you give us through that example wherein like I put my hand in someone's pocket to do pickpocketing, but there's nothing in that particular pocket. So whether I will be held responsible, whether I will be fully liable or not.
Okay. So now in this scenario, if I am just trying to, pickpocket, put my hand in someone's pocket and actually trying to take something, and I find that, okay, there is nothing. So that here would not be punishable, I believe, as far as I know, right? And definitely I would ask Harsh to ponder more in it, right? As to
Okay. So now taking it through where it is relevant to law entrance examination, but chalo, it is again in CLAT 2015. There was a question with respect to a particular person having an intention to pickpocket, and he puts his hand in another person's pocket, but that another person has a loaded pistol in the pocket. The thief touches the pistol and triggers goes on, whereby this particular person gets is shot dead. So then there was a question whether this particular person will be liable for attempting to murder, will be attempting to murder for culpable homicide, and this way. So in these way, the questions run in through the attempt portion, and we must be prepared with respect to this particular thing. Like another example, there was this particular lady who ran to a well stating that she would jump into it. वो कुएं में कूद जाएगी, and she started running towards the well, but she was caught before she could reach it. So again, this comes down to the situation of attempt, which has been ideally been asked by the law entry examination in the past, and it was asked in CLAT 2015 and in PHU examination of 2010. Over to you, Ayushi. You can take it forward from here.
Alright. So now I would like to talk about, now there are a lot of things again when we talk about preparation, attempt and commissions, and you can actually understand it through a lot of examples, right? So when we were talking again about attempt, so how attempt per se becomes possible. So there are a few sections instituted in IPC, the Indian Penal Code, which do not directly call for attempt, but they have actually instituted or they have enshrined it through the sections in it. As I already stated, that attempting to wage a war against the state, or attempting to, commit suicide, as that person said, as Harsh stated, that the person tries to pick his pocket and he finds a loaded gun. So what he was actually doing here, he was doing something, he already only had an intention of picking that pocket, taking that money and going away. But what in turn happens with him is that he finds that there is some loaded pistol in his pocket, and he unknowingly or unintentionally have actually fired it. So now I would like to quote Salmond here. So Salmond has actually stated in one of his theory that something has happened. Okay, there is something that has happened. Now there are two possible. If there is a wrongful act, he was definitely going to commit a wrongful act, right? So wrongful act again is something which is prohibited by law, right? So he was definitely going to do a wrongful act. Now there are two possible outcomes. First is that how he did it, right? It may actually be intentional, and it may actually be on his own intention, right? Accidental or intentional. If it has happened accidentally, then again it comes into a different story. And if that person has done it intentionally, we have one checkpoint cleared. Now the second one is that why would I do it, right? If I had the knowledge that person is having a gun in his pocket, if I had knowledge of this fact that yes, it is in their pocket, and if I fire it, it may actually hurt that person itself, or somewhere someone who was around to that person, that becomes a part of an offense. But if I have no idea what is happening, he is having some you know gun in his pocket, and I just put my hand there and I pull the trigger and something happens, right? That would not directly be because I did not have any guilty intention or any guilty mind of pulling the trigger or killing that person, right? So this thing comes into picture over here. Now, one more important thing that we need to study about is the general exceptions. What are the exceptions here, right? Again, friends, one thing I would like to tell you, that when we are studying about CLAT, when we're studying for CLAT, and when we come to the first part of legal reasoning or legal aptitude or whatsoever, one thing that I have seen is that these principles are already there, these laws are there, but you always follow what they have asked you to do. If they say murder is not an offense, and if there is this question that one person goes and kills B, he shoots him, and the principle is that murder is not an offense, and this person has actually committed a murder. If the option says A has committed murder, A has not committed murder, or whatsoever, so your answer would always be no, he has not committed a murder, because our principle says. But now when we talk about our reality thing, so there are also exceptions to it, right? Exceptions in the IPC. So
Uh,
what?
Ayushi,
Yes.
can you take us through this particular again? There is a question which has been asked in LSIU 2000 and LSIU 2003, and further repeated in symbiosis in quiz examination and CLAT as well, wherein there has been a lot of discussion with respect to even the faculties at different institutions of where does this particular position comes in. Like if I buy a particular gun, I also buy a cartridge, and I want to commit murder of someone. I then set out searching for this particular person. I load the gun, take the aim, and pull the trigger. The gun did not fire. So tell me, in this particular case, which stage I will be guilty of an attempt murder. My personal input is when you pull the trigger, because then you connect the attempt commission part. But a lot of times, students across the country have told me that they have been told कि जब से gun load हुई तब से होगा. So I want you to clear the air around this particular issue.
So even I am of the same view as you are of, that once I pull the trigger is when this crime, this attempt thing comes into picture or comes into action, right? And I have actually encountered a lot of people who have given me the same view, that yes, the attempt begins. Some people say that no, when he buys the gun to kill that person, at that time attempt begins. Some have said that no, when this person goes and loads that gun, at that time attempt have begun. But if I am to present a person, such person in the court, so I would only consider it that when the trigger is actually, I am pulling the trigger and I know that now I have to shoot that person, right? At that time my own intention, I am definitely having my intention throughout it. But when I'm actually pulling the trigger, this is how I would um, play this thing into action.
Again, to the kids, this particular topic has also been asked in AILET 2010 and AILET 2013. The same question in an attempt to commit an offense and with respect to poison. So you can go through those questions as well, Ayushi.
So let us move to the general exceptions now. What there are basically three important general exceptions that we need to study about or read about. Is that first is unsoundness of mind or insanity of accused, right? Now what is unsoundness of mind or insanity, right? So there are a lot of cases revolving around it. There have been a lot of instances around it. What is unsoundness of mind? Unsoundness of mind is something that at that point of time, if I'm committing an act or if I'm omitting that act, I am not in a condition to understand as to what is happening, right? I have no idea as to what is happening. Again, voluntary intoxication is not a part of it. Yes, if someone has intoxicated me and I have no idea, I have no clue that I was intoxicated, I was sitting and having water, and I had no idea that someone has mixed some chemical or some had some put some medicine into it, and I just get up, I drive my bike, and I just ram into some person. At that point of time, yes, but again it would become technically difficult to prove as to someone has put something into it. I was not in a fit state of mind at that time. That comes as a little latter question. So what I need to understand is what unsoundness of mind is. So unsoundness of mind, as you might have also studied in contract, that person who is not in a fit condition to contract, the contract becomes void or voidable at that point of time. Now here also, if there a person is of unsound mind, he's crazy and he has a history of medical reports and everything like that, and he just goes up on the road having a knife, a kitchen knife in his hand, and he just goes and stabs the first person in his eye he sees. And now what will happen? What is the fate of this case, right? So that person at that point of time can definitely plead insanity, that I was of unsoundness, I was of unsound mind, right? Now there are also a lot of words as to what is unsound, what is insane, what is, if that person is dumb, he's not able to understand. So there are these three different categories. When you go deep into the law, you will understand it, right? And you definitely need to understand these things. So this thing is one. Now also it is said that if a person who is a child who's below the age of 7 years, if he commits an offense and if he commits anything, any act or any omission with a criminal intent and which is punishable by existing law, right? That becomes that is not a crime, right? So if there is this child of 7 years, say 6 years, he has no idea, right? Again, pardon me for the words I said, criminal intent, right? So that child has no idea. They are playing hide and seek. He just goes in and put puts the younger brother or the younger sibling or the cousin or the people here he's playing with, children he's playing with, in the washing machine. Okay, they all forget that they were playing hide and seek and everything like that, and that person is suffocated there, right? The child blocks the other child in some compartment, that okay, no, you sit there, no one will be able to find you, this thing is there. Okay, so these things again are important to consider. The next is intoxication of the
Okay.
accused.
Ayushi, before we move on to intoxication, uh, there has been a question around this particular topic of unsoundness of mind. The question have been asked in CLAT 2013, 2015, and before that in NL5 exams. The one and the foremost question which has been asked a lot of time is, somebody takes a son who's a 3 year old and throws that particular child for bathing in the well itself. So here in the question has always come about that the particular whether this particular person was of unsound mind or not. So again, there has been an academic discussion over this particular issue, whether we can consider some sane person throw their 3 year old child for taking bath inside a well. So with respect to this, I would hope that you throw some light on this particular issue as well, Ayushi, before we move on to the other part. And yes, with respect to the age, children below 7 years of age, this particular question has already been asked in law entrance examination, especially SLAT, uh, which is for symbiosis law entrance test, twice, and once in BHU. So you need to also figure it out that this topic is really, really important. Over to you, Ayushi.
Okay. So coming to the point where Harsh asked us that if a person, okay, one thing I would like to know is that, so what that person is claiming, to be sane or insane?
This particular person is claiming nothing. The thing is silent. It's like the villagers rescued this particular child, which ideally, as far as my analysis goes, somebody throwing a 3 year old child take bath in a well. I will consider that particular person to be insane, uh, unsound of mind rather. So, what is your take on this?
Okay, so now what I will consider in this case is that, say I am an advocate of that person itself who has thrown his child over there in that well. So I will strictly and strongly put before the court, or right, that yes, that person was of unsound mind, because he was not able to understand that if there had been a person of normal general prudence, he would have actually be able to understand that if there is a well over there, it must definitely be filled, or it must definitely be deep enough to kill any person, or at least that person could not survive, and especially if there is a child of 3 years of age, right? So if any person is throwing his 3-year-old child in that well, would definitely be of insane mind if he is doing so. Now, if there comes another picture, if we try to add oregano and
Of
chili
course
flakes.
not. Of course not, Ayushi. The answers to these questions was itself the same. That this particular person has committed no offense, and he can plead the defense of unsoundness of mind. So I would ask you to continue to the next general exception, which I believe will be intoxication.
No, so I would just like to complete it that if I someone persuaded me stating that okay, if you put your child in that well, then your whole village will actually receive ample of rainfall, or you will be blessed with a baby boy or a baby girl, and the other your up you will find some jewelry or some gold or some money in that form. So that would again become a totally different picture, even if that person of were of sane mind, but again he was instigated, right? Instigation again is a very important word when we talk about criminal law. Instigated is to pressing or pursuing someone to do some act, right? Now I would not actually derail from the topic. The second one is intoxication of the accused. As I stated that voluntary intoxication plays no role over here, right? Voluntarily intoxication means I was capable to understand as to if I am intoxicated, I may do something wrong, right? And if I am intoxicated, voluntarily intoxicated, I go on and shoot any person. And then if I am standing before the court and pleading that no, I was unable to actually understand the circumstances, the scenario, so that would not stand in the court. Again, the example I stated, if I have no idea what is happening, I'm intoxicated, I have been consistently been, given drugs or injections, right? There was this movie, I don't recall his name. So in that movie, that girl was
Wanted,
constituently,
wanted. It was even done in Wanted.
yes, in Wanted, and one more Akshay Kumar's movie, I don't remember. Used to commit suicide. And it was some funny movie, I don't remember. Yes. So she was consistently she was given drugs, right? And now if I'm given drugs and I have no idea, I am believing that okay, it is for my good health. I am having diabetes. I am getting insulin in that form. But on the other hand, I'm actually given drugs here. And if now in this feat I go and kill someone, or I at least injure someone, not kill but injure someone to a gravity that may person may, you know likely to cause his death, so I will not actually be charged with culpable homicide not amounting to murder, right? Now the last one is right to private defense of accused. Right to private defense of accused is again a very important thing here. Okay, now when we talk about motive, okay, motive may be good or bad, right? If it is wrong, right, if it is wrong, then you will be punished. For an example, if I have a motive of serving people, that I want to feed the poor, I'll feed 1000 people every day. And now how am I doing that? Every day I'm hunting for houses. I know they have good stuff, good money, and I know that just allegedly or just figuratively they have a lot of money, black money or whatsoever. I go to their house, I steal the money, and then I feed the poor, right? I am doing a good work definitely in the eyes of the people, but is it legally right? It is definitely not. Okay, I am feeding the poor, in my motive is right, everything is right, but what I am doing is an illegal act. Okay, so motive itself doesn't make an act right or wrong, or doesn't make it that offense punishable or not. Now coming to the last topic, that is right to private defense. What is private defense? If now private defense comes with a lot of niceties that you consider, that if I am under an apprehension, or I have a reason to believe that some person who is directly pointing a gun at me, whose gun is loaded, and is slowly taking step towards me, and again, reason to believe, I have reason to believe that I may be killed or I may be hurt, right? And then at that point of time, I'm looking around and I find a big iron rod, and I smash it at that person's head. I would not be liable for any offense, right? So it must definitely be done when I have a reason to believe that my life is in threat or danger, mine or someone else's, right? If I am, going in a street, it is a dark night, and that street is a desert, that is a deserted street, and there are no passerbys. I see that a guy is trying to harass a girl, or a guy is trying to beat another guy. Now in this situation, I know that I have no other option. So one more thing that is to be considered, when I was studying law, my teacher also made it very sure for us to understand right to private defense very clearly, because adha gyan is very dangerous, right? In the name of right to private defense, I can keep on going on killing people, right? So it is to be understand that when I have no resort, at that point of time only I can hurt the other person to save someone else's life. Okay, again, it is not written
Or
there.
lost life, or one's own life.
Yes. So this is to be again very well considered, that now I see this guy, harassing this girl, and he is having maybe some revolver, or you know, he may have some other things, and I have no other options. I am not carrying my phone. Even if I am carrying my phone, I'm not able to contact anyone, and I find a log over there, right? I'll just go up and try to smash it on that person's head, so that we can I and the other girl I'm trying to save, we can just run away from that situation, right? In this situation, the private defense would apply, right? But if I have if someone is trying to beat another person, I know that I don't have to pick up a gun and directly shoot in that person's head. I know that it could have been okay. Please don't beat that person. Don't trouble that person. Let's sort it out. If it were a situation like that, right? So it is again circumstances based. If there is a situation like that, that I could have handled that situation, otherwise there were other people trying to, okay, don't fight, the fight was calming down, the people were calming down, but then I'm coming and pulling my gun and trigger on his head. It is wrong. I cannot plead the general exception, or I cannot plead private defense, even if it were me or some other person. Okay, so this is very well required to be understood.
Ayushi, we have two questions from the viewers. One is what sort of cases are considered as criminal cases? Example, if a person threatens to me to murder me, is it criminal or civil?
Okay, so it is civil. It is definitely not civil. It is maybe a harm to my body. So IPC is again divided as to offenses against property, offenses against human body, and if someone is trying to threaten me, it would definitely fall under the criminal case and not the civil case.
Okay, Ayushi, we have another question. What is the difference between homicide and manslaughter? Rather, the particular person has written again homicide and murder. Uh, that is 299 and 300, I believe. So can you just tell in one pointer so that we can continue with the discussion portion?
So now the difference between the two, culpable homicide and murder, is that only, see, if you want to understand this concept, you need to keep in one thing in mind as to degree of harm caused. Okay, harm again is defined in IPC. You need to be very much clear about that word, what harm means: bodily injury, mind injury, physical injury, whatever it is. So if I want to kill a person, if I want to, yes, I want to kill a person, I want to take some revenge on that person, I will go to his place, I pull out my gun and just shoot it in his head, directly here or here, right in the center. This would be murder. Why? Because I have a knowledge here that my gunshot will definitely or is likely to cause the death of that person, right? So that would become murder. And now, if I'm going to that person's place, I am having a baseball bat and I'm beating that person consistently, bashing on his head, breaking his bones, and doing everything, and I leave that person. Yeah, I believe that okay, that person died or whatsoever. Now, what will count in the court is that what was the degree of harm that was caused. Okay, so I smashed 3 times on his head, and I go like, okay, yeah, it is fine, it is done, and that person eventually survives or whatsoever, right? And even if he dies, so that would be culpable homicide, not amounting to murder. So this is the only and basic difference that you need to understand as to the degree of harm caused. And if you read these sections carefully, these are the only two words: likely to cause death, and I means I have the knowledge or the intent that my act will cause death of that person or is likely to cause that death of that person, is the difference between culpable homicide and murder.
Thank you,
I
Ayushi, on this. It was like 6 page long notes which I got in law school to clear this particular topic. And thank you for that. Of course, we were talking about the journal exceptions, and you told us about the right to private defense, and you also talked about intoxication. I will take a minute and take the students through the questions being asked in law test examination. When it comes down to the intoxication, my kids remember uh, the concept of involuntary intoxication. The particular person should not be in a voluntary zone. अब इसका मतलब क्या है to understand what? Like if there is a birthday party and your friends are just asking you, "Bhai, take it," or "Behan, take it," in that manner, and they have asked you like 10 times, "Ki, please do it for me for the sake of Almighty Donald Trump," and to save him, you take that particular drink, and then you start behaving in a manner. So again, you cannot take the defense of intoxication because it was taken voluntary by you. So remember this point. When it comes down to the right of private defense, of course, bachcha log, you have to take it in a compassionate manner. Like, agar class mein, don't do it. If in a class a teacher is throwing a chalk at you or a marker at you, don't start throwing something, your laptop or something like that, at him or her. Or if somebody at your Bagalwala home have thrown a particular potato at your place, don't start throwing a 1 kg brick to that particular person's head. So that way, it has to be in proportionate nature. Secondly, it you should not plan for it. Like somebody, it's always asked in law and examination. Therefore, I'm telling you, like uh, if you are in a particular place and somebody threatens you कि कल आके हम देख लेंगे, like I will see you tomorrow, and what you do is you start preparing for this particular fight. Remember the web series Panchayat, it's an example to that. So you start preparing and you are waiting कि वो लोग आएंगे और आपके पार्टी वाले लोग उसको बीट अप करेंगे. So यहाँ पे you cannot take the defense of private defense कि नहीं नहीं हमने बोला था वो आके हमको मारेंगे, इस वजह से I was ready with knives and bullets and what not. So that is another example which is relevant to law entrance examination. So over to you, Ayushi. We have a few questions. Why Indian laws are very sluggish in awarding punishment to the guilty, even if the case is proven? Why a soft corner on the criminals? Uh, this is a question. I believe this is pertinent to section 53, I believe, where the types of punishment and the theories with respect to punishments are given. So, to this particular, I believe you would like to say that we are going ahead with the theme of retributive justice these days, which has been broken into 3 zones: pre-trial, trial, and post-trial. And in that particular manner, uh, this is why the soft corner exists, because an eye for an eye is no rule right now, and a blood for a blood is not. But Ayushi, if you want to throw some light on this.
Okay. So, well, this is something even I used to ask myself or others when I did not enter into the law school, right? But when I entered into law school, I actually understood that there are very, niche areas that we need to understand and consider. Why law is like that? Why I would like to quote that word, why law is sluggish. Okay. So what code believes, like we have evolved, the law is evolved from custom, from precedence, from the tradition, whatever used to exist, and now we are here, we consider that, right, from judge made law. So we consider that the every person is innocent until proven guilty. And one thing is here, other than that, even if a person is convicted, the court believes that, the law believes that that person must be given an opportunity in totality to bring its fact or to bring its side on the other part also. Otherwise there would have been no concept of appeal over there, there would have been no concept of review there, right? So they are always giving the other party, the other person, a chance to bring everything and to create a balance, right? This is why the lady of justice holds a balance over there, the scales over there, to create a balance on both the sides, that if this person is getting opportunities, the other person must get equal opportunities to bring its side to the court of law. And this is why our procedure, the procedure definitely takes time, but it is just to ensure that the court, if say a person is to be convicted for murder and he's been given a death sentence, now if you are giving a death sentence to a person, you are taking someone's life. So this is why they say that you cannot take anyone's life like that, and you must have been studied the concept or heard about the concept of euthanasia, right? It has always been doing rounds over the internet or otherwise in our um, legal justice system, that should euthanasia be there, should it be criminalized, should it be decriminalized or whatsoever, like that, because you cannot take anyone's life like that. And this is why they give you opportunities, even if someone is being imprisonment and if that person is jailed for say 7 years, 10 years, 14 years, you are taking away those important 14 years of that life. That person may be convicted and maybe he did not have enough evidence itself. Let me tell you that court works on evidence. It won't go if I go and say in the air that नहीं, मैंने गीता की कसम खाई है, मैं झूठी नहीं बोल रहा हूँ, and ऐसा हुआ ही नहीं था या ऐसा हुआ था. It won't stand. Definitely गीता की कसम is important over there, but proof is the most important thing. If you don't have proof, if you don't have evidence, you don't have anything. Yes or no? Ayushi Talwar's case you have seen, right? You must have even seen that movie Talwar, right? Even if you have read it, you need to understand that how they were convicted, on what basis they were convicted, right? How beautifully that case was taken up legally. I won't comment about the investigation or whatsoever, right? But these things are very important to understand, that law tries to give everyone an equal opportunity to prove themselves.
Ayushi, there's somebody who's asking, is encounter by police permissible under criminal law? And it comes along with the term police.
So, counter, like, let me tell you one thing, that if I am someone and I am contesting a case like that uh, before the court, so why police is there? First of all, why is the concept of police there? It is to maintain law and order in the society, right? How can you, there are obviously like that XYZ case that happened in Hyderabad, I won't take the name, right? And now everyone is asking questions, that someone said that, some people said that no, it is completely right, they killed the perpetrator, it was completely fine to do so, and we need to set that precedence in our society and everything like that. And there is also the other segment of society which is saying that, you know, it is wrong. Why it is wrong, and it has been done wrongfully. Now what is encounter, what happens in a police encounter? Okay, let us not go by the definition of Hollywood or Bollywood. Okay, if there is an encounter, the word itself says that you are, मैं तो रास्ते से जा रहा था, भेलपुरी खा रहा था, and something goes wrong. In that scenario, you have no resort and you had to kill that person. Okay, so that becomes a police encounter. So legality, I am no one to question the legality, and neither you are. So that is the question of departmental inquiry that comes up before them, as to what is right and wrong, right? So what I can say is that encounter in simplest words is that if I'm seeing that person and there is some basic scuffle broke out between the two, and they just had to shoot that person down, right, so that they can, you know, allow more raita, it is permissible. But other than that, that is a question of inquiry, definitely.
Okay. Uh, Ayushi, somebody is asking about the difference between criminal matter and civil matter, which I believe you have already cleared in the starting. So, with respect to the matter being intention, and when with respect to the difference between which is it an offense against the state and a right in rem, right in personam. Along with that, there in civil matters, it's all about compensation. In the criminal matters, it's about fine, punishment, etc., etc. So I believe you can watch that in the starting part of the video, Shankar sir. Uh, Thank you so much, Ayushi, for taking time from your busy schedule and talking to us on the basics of the criminal law. Uh, it was very informative when it comes down to the basics of criminal law. Hope we can have you back on another session wherein we can go ahead with the offense against either human body or offense against property. Uh, Thank you, Ayushi.